On February 27, 2025, the state of Wisconsin appeared in Washburn County Circuit Court for a final pretrial hearing in a multi-case prosecution that had been pending since 2022. Nicholas Contreras was charged in connection with allegations of taking and driving a vehicle without consent, disorderly conduct, and a separate felony bail jumping offense. The court presided remotely from Burnett County, while the defendant and counsel appeared by video conference. Two of the cases, both filed in 2022, were scheduled for dismissal after the prosecution concluded it could no longer prove the charges beyond a reasonable doubt. A third case, the felony bail jumping charge, remained pending. As the court reviewed the state's request, questions emerged about how the cases had remained active for nearly 3 years before reaching that conclusion, and whether key issues involving the alleged victim much earlier in the process.
We will go on the record in the matter 22 CF 87, 22 CF 114, 22 CM 52. State of Wisconsin versus Nicholas Contreras. The state appears through Assistant District Attorney Christian Ness in Washburn County Courthouse. We have Adam Welch appearing by video conferencing with approval of the court. We also have Mr. Contreras appearing by video with approval. This court appears in Burnett County Courthouse by Zoom to Washburn County. We're set here today for the final pretrial in all of these cases. I have received and reviewed the state's request to dismiss 22 CF 87 along with 22 CM 52. I've reviewed the basis for that request in the fact that the court or the state believes that after thorough review and preparation for the trial, the state believes that they lack further merit and they could not be able to prove to a jury beyond reasonable doubt and prove guilt beyond reasonable doubt in these two matters. I'm going to ask the state for a more thorough statement as to those cases, and then I'm going to ask the state if that is applicable to 22 CF 114, which is a felony bail jump. The basis for that felony bail jump is being on the felony bond in 22 CF 87 and being pulled over in Burnett County and operating with after revocation. So therefore, Mr. Contreras was driving without having a valid operating privilege. So Mr. Ness, first off, does the request to dismiss include 22 CF 114?
No, Your Honor. I submitted a request for the two that are scheduled for final pretrials today. I think that the factual basis and the reason for the dismissal is separate from the bail jumping case.
So we're continuing with the jury trial for this felony bond?
I don't believe it has been set for trial yet.
Oh, I'm proceeding with this trial on that date and time.
Okay. My understanding is it hasn't been set for trial. I'm fine.
Oh, no. All of mine are backed up. If one resolves, then it goes to the other one, and then it goes to the other one. So this court will proceed with trial on that felony bond case unless the state is telling me it's dismissing it or it's resolved, and that's here today. Because we have the jury trial set and scheduled already in these cases, and all the time, that is this court's policy. It is always fallback. If one resolves, then we move on to the next case for that jury, and if that resolves, we move on to the next case. So in this court's, in looking at this case and in these cases, we are set to go to trial then on March 25th for a felony bond jump, unless the state tells me here today that it is either dismissing the matter or the matter has resolved.
Understood, Your Honor. I don't object to that. The only reason I did not think that was because the calendaring, it has been set for a status conference today and for that date. I don't put it on my calendar that way. I'm not the one who sets it on my calendar, but that's how I work. So if you need time to talk to Mr. Welch to see if it can resolve, we can have a later hearing today since this is our final pretrial, and you can inform the court on whether or not we're going to proceed. But at this time, I am not dismissing any matters until I hear what's going on with 22 CF 114. Well, understood, Your Honor. I don't think that further discussion is necessary. I think that the parties have thoroughly discussed possible resolution. I just don't think that there is a resolution at this time. I could talk more thoroughly about 22 CF 87 and 22 CM 52. In each of those cases, it's the same victim. The victim in both of those instances has requested that the cases be dismissed and has made statements to my office to me, including that because of a traumatic brain injury, she has no memory of any of the incidents that are the factual basis for either of the crimes, and that she would not be able to testify to any of the facts within them. And so I believe that constitutes essential facts under both of the cases. And so without that testimony, I don't believe that I can proceed.
When did she have this traumatic brain injury?
I think she's had this for years, Your Honor.
She's had this for years, and prior to, are we talking prior to these incidents occurring?
Correct.
And from 2022, from July 27th, 2022, and from July 28th, 2022, up to February 27th, 2025, I'm hearing that the state in no way, shape, or form ever talked to the victim in any way prior to those dates and times, which were going on 3 years, 2.5 years, never from that time spoke to the victim about her TBI and whether or not she would recall any of the incidents and as they occurred or any of the facts. That's what I'm hearing. So I'm hearing that we've had a tremendous waste of resources. Is that what I'm hearing, Mr. Ness?
No, Your Honor.
That's what I'm hearing.
Your Honor, I've spoken to this victim previously. This was a revelation later on in the case. She has, frankly, Your Honor, I'm not certain that I find her statement regarding her traumatic brain injury to be entirely credible. But if an individual is making that statement to me and is indicating that they would not testify to the essential facts of the case, I don't believe that I can call her and expect to prove a case beyond a reasonable doubt.
You still have a duty to subpoena her and call her as a witness, even if she is a hostile witness, and you have the ability to at least try and prove the case, because we are talking, there may be allegations against her. There's a take and drive without consent. There's disorderly conduct. Those are things that you may not need the victim to have full ability to recall and to testify about, correct?
That may be true, Your Honor. I've discussed this with the district attorney. I think it becomes a delicate issue because the public policy consideration is not to treat victims of crimes as though they are criminals. And I think that the forcing a hostile victim to testify and putting the force of the state on them through a subpoena, I think it violates that public policy consideration of my office.
So from July 2022 up until just recently, and I'm going to say, I'll even give you a little bit of credit, last week, up until then, victim was, yep, I'm ready to go. I recall all of these things. Let's go. And then last week or I'll even give you 2 weeks. She was like, oops, nope, I don't recall. That's how it went down?
No, Your Honor. This happened previously. It has been discussed with, there was a request. I made a statement on the record regarding a witness changing her story. The defense attorney at the time met with me in my office with an investigator. I disclosed what had happened and what was being discussed. There was a proposal for a global resolution as to all cases. And I believed that it was possible to resolve these matters globally on a misdemeanor basis until recently.
And Mr. Welch, there is what I'm hearing, at least from Mr. Ness, and I'm going to not take into account the two serious matters, but to the felony bail jump, there's absolutely no way that this matter is going to be able to resolve and we're going to trial.
It certainly could resolve if Mr. Ness wants to, but there's not a resolution right now.
Because I can give you the day, because today was my day.
If Mr. Ness wants to talk about it further, I'm happy to talk. If he tells the court that there's no point in further discussions, then we'll have a trial.
Mr. Ness?
Well, Your Honor, my understanding is that the proposal from defense is to plead to misdemeanor bail.
Your Honor, I'm sorry.
For a fine.
Sir,
Well, no, and Mr. Welch, I'm going to ask you anyway. I have the right to ask what the offer is. I have the right to reject any offer in the public interest. And if he's saying it's a felony bail and your offer was to amend to a misdemeanor bail, boom, there.
Understood, Your Honor. I just don't want to create a situation where the court's pressuring either side. So
I'm not pressuring
I
any
didn't say
side.
the court was. I just was trying to head off that possibility, but I apologize.
My pressure to both sides are we going to continue to use government resources since 2022 until 2025, and then go forward with a trial with a felony bail, which I am fully prepared to do. I have 2 days set aside on my calendar, 2 full days set aside on my calendar, which is a lot because I am a very busy court. So I have 2 days on my calendar to have this jury trial. So I just need to know if there's a potential ability to resolve or if we are proceeding in a jury trial fashion.
I think I've made a proposal to the state, and if the state wants to discuss it further, I'm happy to discuss. If the state is just telling us that there's no reason to discuss further, then I'm prepared to go to trial as well.
I
Mr.
don't
Ness.
think that it's likely to resolve, Your Honor. I don't think that there's a point in further discussion.
All right, then we're going to jury on March 25th for a felony bail bond violation case. Everybody's ready to go?
Your
So
Honor,
that means I need everything filed. Today was the deadline, but I'll give you a week to get everything filed. I'll extend it to a week since there was misunderstanding as to how this court functions. 1 week. All discovery, all witness lists, all motions in limine, all necessary documents needed for the trial. And we will see you on March 25th. And I'm going to tell you, this is my drop dead date. That means I will not accept any agreement passed today. We are done with negotiations. We're done with resolutions. That means this trial will proceed. The only way it will not proceed as a trial is if Mr. Contreras pleads guilty to the charge. Whatever the resolution is, that's for argument's sake and for whatever can be negotiated. But with regards to that, either he pleads to the charge or the state dismisses it. But we're going to trial March 25th on a felony bond violation. Because we all have that day set aside. Court has it set aside. I have it set aside. Mr. Contreras has it set aside. And it is in the public interest to keep this matter moving. It is a 2022 case. We are now in February 27, 2025. Do we have any questions?
so Your Honor, is the court signing the orders then on the 2 other cases?
Well, if I'm hearing from the state that they, from July 2022 until February 2025, had no idea that the victim had a TBI and had an ability to recall certain facts and would not make a good witness, and they can't prove their case. And it's been going on for this long and using all of these resources. I guess it's kind of a quandary for the court. I can't force a trial upon a victim who would be put through the ringer, and quite honestly, a defendant and the public justice system. Resources have already been wasted. So I will sign those 2 dismissals, and I will see you for jury trial for the felony bond jump violation. And with regards to that case, what I'm going to do is I have cash on the other matters. I'm transferring that to 22 CF 114. I'm making sure that the bond is applicable to 22 CF 114. It is. It looks like it's filed in 22 CF 87, and it says the bond to cover all of the cases, same conditions as previous bond. So same bond, same conditions, same cash. We will see you March 25th. Be ready to go.
Will do. Thank you.
Thank you.
Ultimately, the court approved the dismissal of the 2 underlying cases while allowing the felony bail jumping charge to proceed to a jury trial. Firm deadlines were imposed, bond conditions were transferred to the remaining case, and the court made clear that further negotiations would not be entertained. This proceeding illustrates how late-stage prosecutorial decisions can reshape a case after years of litigation, raising broader questions about efficiency, oversight, and accountability within the criminal justice system.